can see it in our eyes. We are the revolution. We want it all tonight. We want to take back what's rightfully ours. We are the
of the Justice Committee. First of all, I'd like to say I'm sorry that we've kept you waiting for 20 minutes. We ran over time this morning, but you have our full attention now. Please have a seat. So we've got your written submission that we've had a look at. Yes. You're welcome to take a seat as well. Do you have people as support people?
Yes, I have. This is, my name is Brent Andrews.
Brent.
Brent's
nice
a
to meet you,
victim.
Brent.
And this is Stephanie Lee. She's also a victim.
Hi, Stephanie. And you're welcome, another person as well. Sorry, please bring a seat round as well. So have a seat. You're before the committee. We've allocated 10 minutes this morning, but I understand from the clerk that more than one of you might want to speak today. Is that the case?
Be fantastic.
Great. We do have only 10 minutes. And typically when we're hearing submitters, when someone gives us a submission, as you have, Steve, it's just them who speak. But given the fact that you're a group and I know that there are some other people, if you can be economical with your time as much as possible, I'm happy to hear a few other people's points of view as well.
Fantastic.
I know that you've had a long trip down all the way from Auckland, so thank you for making the time to come and see the committee. I just want to be sure that you're aware that we will make public what you've said, so that's important.
Well, that's one thing we were going to bring up. We're very concerned it actually rattled us, actually.
Yep, no, I appreciate the fact.
We have a democratic right.
No, and that's exactly what the select committee process is here for, is for your story to be told, and I want to be very clear that that's the case. But saying that though, we always have concerns about other people's rights as well. So in terms of natural justice and of naming other people or naming things that are before the courts, those are issues that we need to be watchful of to make sure everyone's rights are protected. But to give preference to be able to hear your story is the number one. So what we will, the committee is determined to do is to record today's process, and if we're making sure that all those natural justice provisions are adhered to, then we're happy to make public the record today on that basis.
Well, please understand our New Zealand Bill of Rights 1990 section 14, which was the very first part of my submission, because one of the problems is the voice of the child and even the parents' voices are not heard because of the secrecy of the family court.
Well, they're the things that we have to take a look at. So we have your written submission. I'll start it now for 10 minutes, and we'll see if you're at the end of the 10 minutes. I'll indicate when that's coming up, and we'll give you a bit more time if you've still got a few bits to get through. But please take us through your submission. Just pointing out too that because we've read your submission, you might want to just bring us to the parts that you're most wanting to get across as part of your story.
Okay. Well, thanks for you going to publish this submission, because we're a very, very large group. We started off as Families for Justice, and we decided to become a much larger group across New Zealand, and we're a very united group. And there are hundreds of thousands of disenfranchised New Zealanders from every race, from every gender, and from every religion. So one of the things that you wanted to do, and the public I'd like to know, is to even be here today because of the secrecy of the family court. I had to write 3 submissions, and in the end I had to leave it up to a barrister to finish it off so that I could continue to drive from Auckland to Wellington to be able to present this to the Select Committee today. So one of the things we've talked about, and I understand, was we want to explain to the committee that we have evidence. You know, I'm an engineer. I'm not a conspiracy theorist. I am an international award-winning exporter on more than 2 occasions for New Zealand companies, as well as a British one. So we deal in facts. We're not trying to hype this up to be anything more than this is real, that is going on in the New Zealand Family Court and their associates, and they are abusing the families. And that is what is causing all the harm. Right, so we looked at a very high profile case, but one of the things we want to talk about is there's really no such thing as the voiceless. There's only the deliberate silence that's enforced upon us by the state and the rules that they're putting in place, that we are unable to be heard. And so behind closed doors, corruption and lawlessness within the family court is outrageous. And there's an example of this. As I said, we've had to put together 3 separate submissions to try and get within the rules of this lawlessness to be able to tell the truth. The truth is never being heard at the present time within the family court because it's a secret place. It's a very secret place. And we're threatened by the state to keep our mouths shut. And we're forced by law not to be able to voice our opinion at the lawlessness that's being inflicted on us by the state against our families. The ministers need to change the laws so that these people can be heard. And this is an intergenerational problem. You know, the kids we've got today, they're the adults now, or will be the adults soon, and they will have the same problem of not being heard. The situation is so dire within the family court that I do wonder at times what it would be like if all the family court victims just breached civil disobedience and published all their family court records online. What is the state going to do? Are they going to put all these parents in jail? The taxpayers wouldn't be very happy about it, and you haven't got enough jails. You know, there's 60,000 consumers going through the family court every year. It is outrageous, the lawlessness that is going on. I am a victim, but one of the high-profile cases, we have included 2 newspaper articles, and that seemed to be a bit of a problem for the committee. That particular person was trying to protect his children, and he had to protest and get on a plane outside of the jurisdiction of New Zealand to protest in another country, to put the information on YouTube by a gentleman called, it doesn't matter, but it was another gentleman, to be able to supply the information to ministers of the Crown. Every single minister of the Crown in 2014 got those videos. Over the years, only 3 ministers ever contacted him. One of them believed that it couldn't happen in New Zealand. The history is it did. And those children were used in a domestic drug operation by the state for 2.5 years. The father feared for his children. He lived on adrenaline all for 2.5 years when the drug dealers came to this gentleman's house and tried to intimidate him with an AK-47. This was real. This father had actually been to the New Zealand police and had figured out they weren't going to help him and didn't realise he was actually taking on the whole of the state of New Zealand. The Organised Financial Crime Agency of New Zealand, which operated out of the Prime Minister's office. It's now moved out of the Prime Minister's office since this operation, and it's now part of the New Zealand Police. Clearly, from the newspaper articles, this particular victim was right. But some of the things that were really strange in the case was the vast difference in comments by the judiciary. One judge said that the application was brought to by the father to remove the children from the mother on the grounds to embarrass the mother. And that was after the first drug operation, which was in Glenfield, in the King Storage Lockers, where he was manufacturing methamphetamine. 2.5 years later, when the father threatened the clandestine lab people and members of the police that he was going to bring in an international rescue team from offshore, did they take the steps to arrest those people? And then the vindictiveness of the state thereafter to threaten this father by taking away his security license, which was another example. Now, one of the things is there is evidence, clear evidence, which we can't show you because we're not allowed to, the relationship between what the police were doing and what Auranga Tamariki was doing. It was Child, Youth and Family there. But all those organisations breached their statutory legal obligations of welfare and safety of the children. You know, the reason that SIFs and OT are set up is to protect those children, but they didn't. What they did is they cooperated with the New Zealand police. And the police breached their Police Regulations Act 2008, which is the Care of Child Act 2004, which is welfare and safety of the children is the first consideration and paramount. And then the police took away the father's security license, so he wasn't able to work. And I understand that he was a multi-millionaire back in 2014. He owned a freehold house in Auckland, so he must have been, because every house is worth $1 million there now. And he's now living in motel accommodation with his son that he was awarded. But his daughter timed out and suffers the classic symptoms of parental alienation and was abandoned by the mother 2 years ago. The court and Auranga Tamariki and the lawyers for child all decided that the daughter would have been better with the mother, but it wasn't true. But there are more than this. You know, I've got an example here of absolute lawlessness in the family court. We've got another one here of a little child that cannot give its voice, that's sitting in a hospital right now. And there are examples. So we formed a group called Families for Justice. 70% of the group are women. So we're not a gender group. So we're not misogynists and we're not feminists. We're just parents. And that's really important. We're not interested in gender. We're not interested in religion. We're not interested in race. But what we find, the biggest problem in our grouping is that the court cannot decide who is the protective parent and usually goes after that parent. And the reason is because that parent is really determined to protect their children. It's a natural instinct. And if, with all due respect, if you had someone trying to shoot you with a gun, I'm sure you'd find that your natural instincts would come out. There are many other people in our group, like heroes, like Jean Tahuia, the midwife, who stood down the New Zealand police, the whole of the government, on this all-of-government approach. You know, Not One More Baby is one of the groups that we work with. You know, we've got SIFs fighters, we've got Auranga Tamariki, Dirty Rotten Scoundrels, and Kids for Justice. But that is only one, a few of the groups that are spread across New Zealand to become this united group. That was formed with Maori people. Fantastic bunch of people. We didn't get anybody who would listen to us until we decided to be lawful and start protesting outside judges' houses and use Brooker versus New Zealand Police Supreme Court of Appeal to do such a thing. But we're still not being listened to. We've backed off for a couple of years, but nothing's happening. We thought we were on luck when Andrew Little decided to do the New Zealand family court law reform, and there's been absolutely no changes. It's still a lawless, corrupt outfit. When we say the system is lawless and corrupt, we don't want to make that sound like that is a throwaway comment. We're saying that with real determination and facts. That's what we really want to be able to put before you people. There are facts, right? And not just that, some of your other ministers have made similar comments. The perjury is rife within the professionals, and the defendants can't be heard. The lawyer for child, honestly, Simon, if it ever happened to you, you'd be very disappointed at behaviour of some of those lawyers for child, right? You know, one of the things we've all been watching, some of the production produced by the committee, and one of them was, I think, Birthright. And she mentioned a lawyer, and we're not going to mention him, but he was involved in this case of one of the case studies we've talked about today. And here's one of the leading lawyer for child in New Zealand, and he knew that these children were involved in this drug operation.
Can I know, Steve, you've got a lot there. Just checking if there's other people that want to speak. We're well over the 10 minutes now. We're gone a fair bit over that. So if you can have a couple more minutes to wrap up and check if there's anyone else who'd like to offer some comments today.
Would you like to say anything?
Yeah, I would. Please excuse the shaky voice and all that. You know, emotions are pretty high right now. But if I could just give a little, like the briefest version of my story as I possibly could. I come from a very abused childhood myself. I then became in abusive relationships, stuck in a very abusive relationship that I finally escaped with one of my 5 children. I then got my younger children. I moved away just to escape the relationship. I moved back and gained back my youngest 2 children. Some things happened in my life from my childhood where I was taken back to court as an adult for propensity evidence to put somebody else that has reoffended and bring justice that I never received as that child. And in that moment, my trauma was used to take my children based on lies, false allegations, false statements. Without notice, I lost my 2 youngest children out of 5. I was already a grandmother. Now, I turned everywhere I possibly could for help, everywhere, including the police, hospital, SIFs, WINS, IRD, Te Arakoro, so many places. But because we were before the family court, there's no help whatsoever. 18 months or 15 months or 12 months maybe into family court, the lawyers, the psychologists, the court, they couldn't work it out. So they hired Oranga Tamariki to investigate. 2.5 years this investigation went on. And I never, ever had a court hearing, never, ever allowed to defend the original allegations that went to the court that lost my children. And I fought tooth and nail because I was innocent. I got my official police information to prove my innocence, but I was told that needs to be left for the judge for a hearing. Okay, 5 years in that family court, I never had one court hearing, not one. But I was a protective mother and an innocent mother, and I fought until my children got police evidentials. Right up until that day, I was told nobody can override a court order. The day my children's police evidentials were heard, the court order was overridden. I still have never had a court hearing. I've been discharged, and I've had my children back for 3 years. And the damage that still continues today is immense, totally immense. This one case alone has cost our country and our taxpayers $1 million plus. Me and my children are still in therapy, but that's not the end, because this broke apart an entire family. Today we are still very much broken. We have no justice, we've had no voice, we've had no help. But my God, have we been judged and ridiculed so harshly, so harshly. And it's not okay. One thing I'd like you to all think about or go and have a look at is me speaking in here in this room on the perjury bill about this very same stuff we're talking about today. Do you know what upsets me the most? It's not one person ever has ever come and asked me any questions about it. And I have reached out to members of the Parliament, the Ministry of Justice. I went to the justice thing in 2018, and there was a lady in that room that stood up about the family court and the oranga tamariki that day, never ever broadcast. That lady was me. And I'm not going to stop speaking up, and I'm not going to stop fighting, because there are other families out there. I've got my kids back. I should be happy and living off my life, trying to do what I can for my children. But there are far too many people out there like me, and my children suffering for no goddamn reason.
Thank you. Thank you very much. Look, I really would like to make a point of thanking you for coming in, for telling your story, and making the time to give this committee an insight into what your lives have been through over the past years, specifically to the family court.
Well, one of the things we're trying to
Can I
explain to you
finish? Can I just finish?
The voice of the child can never get listened to over the din of the professionals and the state, which is outrageously, lawlessly, corrupt and out of control. And, you know, the people, you don't talk to them like I do. The hundreds of thousands in New Zealand are getting angry, like really angry. And Oranga Tamariki, it has taken us years to prove that they're a lawless, corrupt outfit, right? And you've got 250,000 to 460,000 who are now on the Royal Commission of Sexual Abuse, saying they were abused in state or faith-based care. Are you kidding me? You people don't listen. You ministers of the Crown are not doing the service to us, the people. And you need to buck your ideas up, because we're getting really angry. And we went after Tracy Martin because she wouldn't listen to the victims. We got rid of New Zealand first. Do not underestimate the power of your people. They are really seriously angry.
I hear that, Steve, and I thank you so much for coming in today. And that's the conclusion of today's submission. So thank you for coming in.
Thank you very much.
Thank you for your time.
Thanks for sharing your story.
Thank you so much.
Submission. For the NZ Family Court, supporting children in court, legislation bill. Submitter, Stephen Douglas Evans. 027-433-8267. stevedouglasevans@gmail.com. Author Steve Evans Families for Justice Limited. I am expressing my NZ Bill of Rights 1990 Section 14 with a large group of New Zealanders who are united. Freedom of expression. Everyone has the right to freedom of expression, including the freedom to seek, receive, and impart information and opinions of any kind in any form. The comments I make are substantiated by evidence and personal experience to my children, myself, and the numerous people that have stories and experiences that I have met that are worse than mine. A high-profile case. https://www.nzherald.co.nz/nz/judge-slams-for-cries-for-help-as- Children live with gangster in alleged P-Lab/K Blue Yalsvki 46 HCTBYF5 Omelra/ https://www.rnz.co.nz/news/national/4223344/police-attempts-to-stop-man-running-security company-. Overruled in court. John, not his real name, so as not to breach family court publication rules, and his children have lived experience of lawless and abuse by criminals, and the all of state approach at the same time since 2014. And the state has continues its persecution as a whistleblower. Until those that have abused us are held to account, he will be persistent so that no other family goes through anything like his. The NZ police and OT used John's children in a police operation and refused to protect them. John has seen fabricated evidence about himself, and his address has been leaked by the Justice Department to the drug dealer whose henchman came to his house and been denied employment and business opportunities because of the state behavior to attack his reputation. In John's case, the state refused to protect John and his children, who the state saw as collateral damage, to remove drug dealers with firearms history from our society in a police operation, 7 in jail, 2 doing life. John spent the last 6 years in court, and before this had money in the bank, a company, and a freehold house. John is now broke with health issues and live in emergency accommodation with one of his children. Because of the duration of the drug operation and the court, another child was alienated from him, having all the philological issues of alienated child and will never reach her full potential, and was abandoned by the mother who disappeared overseas. On many occasions the judiciary was on a personal agenda supported by the neo-judge. Lawyer for child did not administer the law but made outrageous comments like, "Hey John has brought this application to remove the children more to embarrass the mother than the best interest of the children." Yet others commented John is a predictor of the future, or John was tireless in trying to protect his children. The different opinions between judges was vast, particularly from 3 female judges who threatened him with contempt of court and legally abused the rule of law. Who am I? I have seen similar things in other cases. I cannot get my NIA database under 2 different political parties and justice ministers so as to defend fabricated evidence and my reputation. The police have viewed my NIA 1,800 times since 2014, and I have evidence that the NZ police are breaching the OIA requests. I have been treated worse than a terrorist, not a father trying to get justice against the all of state abuse and protect his children and other vulnerable targeted individuals in our society, or a human rights defender. I previously worked for 2 export award-winning firms and ran my own company for many years that had to take on the all of government lawlessness against the ministers, experts, so-called professionals, the police, and the social workers that lied. I have 2 court decisions detailing only some of the abuse, and yet not one individual has been held to account. The professionals didn't listen, the systems that was supposed to protect children didn't work, in fact deliberately ignore me as an adult, so there is no hope for a child to be heard. Against all the agenda of state-funded employees and contractor unless a completely different system is implemented. We had high hopes with Andrew Little's family court reform investigation, only to be bitterly disappointed, just as New Zealanders have over the numerous reports on OT. I protested outside the jurisdiction of New Zealand, outside New Zealand consulates, and supplied every minister of the Crown video copies as well as OT police and lawyer for child to get my government to protect my children, and they did nothing, breaching their statutory legal obligations of welfare and safety of the children is the first consideration and paramount, just words in a legal book and not a reality in the system or the state. Even going to this length as an adult I could not get heard, so how is a child to be heard when the professionals lie? Who are we? United Families for Justice Ltd, Justice for Kids, Ministries for Families, not one more baby, and many others. This isn't to take away effort for numerous other entities in New Zealand complaining about the abuse and lawlessness of the NZ Family Court, is a non-profit organization of fathers, mothers, grandparents, and children, one of New Zealand's biggest gangs, who have been negatively impacted, re-victimized by the maleficent activities of the family court and their associates. OT/CYFS, Lawyer for Child, S133. Report writers, police, and the behavior of the judiciary breaching our and our children. Human rights, Bill of Rights, rule of law, natural justice, and enforcing the existence of the arbitrary rule, the industry. We have bombarded social media, assisted mainstream media and individual hero reporters, written or made programs, protested and given the victims a voice to at last convince the public with overwhelming evidence that OT is a sick, unfixable, corrupt, and lawless organization and the sick culture where the judiciary have been rubber stamping OT applications, destroying families, in particular children, for years. The buck stops with the judiciary and the ministers pushing eugenic type social engineering. It's time minister woke up. And Tali said, in Sep 2015 the government is vowing to overhaul child care protection services after yet another report highlighting its failures. Ms. Tali says the state is not a good parent. https://www.tvnz.co.nz/one-new/new-Zealand/minister-some-parents-could-be discouraged- from having more children. Q12636. We have loudly made it our intention clear to remove any bureaucrat or minister that refuses to listen to the victims and not take action. Moss, Lambert, and Martin Argania Euro so is. NZ first. This should be a clear warning to those in power. We are ready and willing at all cost to protect our families and our rights and demand change. https://www.rnz.co.nz/new/te-manu-corey/434972/orange-40-5-executive-grain steps down. https://www.rnz.co.nz/new/te-manu-corey/434972/orange-50-executive-grain steps down. This goes for any party. Grassroot NZ is no longer going to put up with the status quo and harming our families. OT failed its obligations under New Zealand law and international law. Referring to his report into uplifts and without notice Section 78 applications. In the example above, OT and the lawyer for child used a without notice application on John, and he was the only one trying to protect the children. The judge supported the state as usual, who is supposed to be independent of the state and administer the law, saying I only listens to the professional and not the parents. The professionals clearly lied, as we had 7 arrested days before the hearing. Without heroes like the midwives and Jean Te Hui and Malene Reid that took a stand, there would have been continued lawlessness across the land. An orchestrated litany of uplifts. Newsroom. https://www.newsroom.co.nz/another-damning-report-on-ot-taking-babies. Our children's voices are manipulated through these agencies and lawyer for child who cherry-picks and misleads the family court on their voices. Children have a right to know if an employee of that state or contractor has quoted them, and if that statement is true and correct. In John's case, how do you accept a child's voice when they are in a dangerous place with the dangerous parent and surrounded with Class A drug dealers with firearms? History of AK-47s, and the state agencies are breaching their statutory legal obligations. Family court review: we're failing traumatized children and traumatized parents, causing mental health issues and suicide. https://www.rnz.co.nz/news/national/389236/family-court-review-we-failing-to-raumatiste-children. Restructuring CYF was one thing, Ardern said, but a more holistic approach right across. Government was needed to make long-term change. Well, that hasn't happened. https://www.stuff.co.nz/national/politics/74459494/Jacinda-ardern-good-place-tobe-. A child. Our message wasn't being listened and ignored until we protested outside CYF/offices. NZ police stations and judges' homes, lawfully, re our Democrat rights, NZ Bill of Rights. 1990 and Brooker v. NZ Police Supreme Court of Appeal, which is clearly our right to protest in all civilized and transparent and healthy democracies, and got significant media attention as a result and public attention on the issues being created by the NZ family court proceedings. Abuse and unlawfulness of the family court associates. As a group we have criticized the politicians, judiciary, CYF/OT, police more than any other, and ironically it is our actions in being able to do so that is bringing justice to the table when the judiciary's actions have not. The citizens will no longer stand for this abuse to our children or us, and take note, the citizens are rising in lawful rebellion. 1215 Magna Carta Article 61, of which as responsible citizens we are entitled to do and stop this criminal abuse by state employees and the judiciary on us and or children. https://www.nzherald.co.nz/northern-advocate news/article.cfm C_ID equals 1503450 and objected equals 120022243. Andrew Little also commented that we should not be able to protest outside judges' homes. Yet he was union a representative and had worse tactics than us, which we deem ironic and hypocritical when these judges are in our homes making rulings that hurt our families and rubber stamping the lawless activities of CYF/OT and the NZ police enforcing them. See Ombudsman report into illegal uplifts. Are we to take the steps to protest outside social workers' homes, police officers, and ministers' houses to get listened to? New Zealand is just too small to hide. https://www.tvnz.co.nz/1-new/new-hyphen-just-hyphen-need-police-protection over custody disputes before court. Andrew Little. In his comments to TVNZ he wrongly accused us of being a group of angry dads angered because we have lost visitation. This is completely untrue. 71% of our membership are mothers, and we are angered because family therapists deem the ruling of our cases not to be in the best interests of our children, showing the law is out of step with what the judiciary are suggesting they are educated to rule on or even following the rule of law. Only one of those issues is the complete removal of a parent from a child's life for whatever reason, but most often based on without notice applications citing only one side of the story where perjury runs rife. What this media attention achieved is people recently separated, and needing advice on custody matters, contacting us and us being able to help get parenting agreements on the table for them for a few $100, finalized in a month. We want to acknowledge that we are aware that some parents don't want their child, a small minority, some shouldn't have their children, due to mental health, violence, drugs, and alcohol, and those that want to be in their children's lives and have a legal right to, should be supported and encouraged to stay connected and less dangerous, not because they are combative against the state, predominantly combative against OT social workers that have lied, or a lawyer for child who has lied, taking their children. All families for life orders should be seen as temporary orders, as in European human rights courts. Many examples of judgment against Norway. Loven v. Norway is one example. Worse is the continued secrecy of the family court, and the ministers and crown law further protecting bureaucrats like Section 444 of the Orangatamarici Act and the Contempt of Court Act 2019 are further steps for the state to gain immunity, protect itself and not the citizens, to express our right to freedom of speech, to complain and to hold people to account makes absolutely no sense and reduces the ability to clean out the trough of the behaviors we are stating exists in the culture of state employees in the end, further protects and encourages the lawless behavior and culture by the state against families. In February 2000, a UN report of the Special Rapporteur drew his concern at the independence of the judiciary administration and impunity of judges E/CN.4/2000/61 in the New Zealand judicial system. The Office of the Judicial Conduct Commissioner was established in 2005, and the role was to enhance public confidence in the judicial system and to protect the impartiality and integrity of the judicial system. The Special Rapporteur concern was a system to discipline judges, and this has never been addressed, and the judicial elite are not interdependent of the state in the eyes of the people and show a complete absurdity to be above the law or to administer the law in any shape or form, and far too often in the family court the decision are based on personal opinion. In 2000, the UN Special Rapporteur expressed surprise and concern that there was no process in NZ to formally discipline judges for misconduct. Report E/CN.4/2000/61. Independence of the judiciary administration and impunity of judges. In answer to this, NZ brought into law the Judicial Conduct Commissioner and Judicial Conduct Panel Act 2004. IST. August 2005, the Office of the Judicial Conduct Commissioner opened its doors to receive complaints judges. From this day till 2019 there was 3,056 complaints made. 0 have succeeded. The Act purpose is only for the removal of a judge against the UN expressing concerns about disciplining a judge, and in 21 years NZ does not have any formal process in place to disciplining judges. That's why no complaint has been upheld. The NZ government has winked its citizens, and the UN mislead and gives immunity to the judicial elite for their support of the state against citizens. The point is the family judges clearly have been lawless, colluding with OT in the abuse of uplifts and Section 78 as pointed out by the Ombudsman's report and the action taken by Jean Te Huia in the Waitangi Tribunal, and have been terrorizing families and breaching the Children's Universal Declaration of Human Rights Article 12. 20% of the cases we see are worse than mine, and 60% of the cases we see are in poverty or mental health. Most need a helping hand up and not another hammer on the head. Until poverty, homelessness, drug addiction, and mental health improves, there will not be any improvement in the lot of the lower echelon of New Zealand society or their children, even if the voice of the child is heard. The Royal Commission of Inquiry into the Abuse of Children in State Care and Faith-Based Care, including Lake Alice, is a clear example of how shocking the system, NZ Family Court and its associates, for decades has ever listened to the voices of the children. Against the state, estimates 250,000-460,000 victims, it's taken decades for the NZ state, under any party, to address this, as the state is the biggest abuser and the children ignored. To the extent many are adults or grandparents now or have died, and it is carrying on to this day. Clearly ministers and political parties and the state have failed the citizen, and no one is held to account. It is clear that the balance of power of the state v. the people is out of Control with the judiciary supporting the state, like Crown law, instead of promoting justice, where the judiciary is supposed to be independent of the state and the interloper between the overwhelming power of the state and the fragile rights of a citizen. The result for parents or child is injustice and irreparable damage to the family unit and the inability to reach their full potential, and they become a burden on the NZ taxpayer. For years group members have written submissions, emailed parliamentarians, and complained about the damage to family relationships the family court is doing. 1. The judiciary. 2. Parliamentarians. 3. CYF/OT. 4. NZ police, and to key stakeholders and people in the community in writing and in person. 5. Lawyer for child and physiologists. We have been ignored. The bill. There's really no such thing as the voiceless. There are only the deliberately silenced, or the preferably unheard. The intent of this bill seems to be to give children a greater opportunity to be heard by the court, to ensure their views are taken into consideration by tweaking the law rather than fixing the system, and to appease the UN criticism of New Zealand enforcement of UNROC, and is not to address the failed, lawless, corrupt system and professionals abusing families. Rather than examine just a bill with proposed lightweight words which may increase the chances of a child's views being considered, it seems appropriate to address the complete mechanism where it fails, or as it should be referred to, the act of war that has silenced the child completely, without their consent, knowledge, or understanding, and address the issues related to, not give more power to those that are not representing the children's views honestly. However, it seems a total waste of time and taxpayers' money not to address the core issue that the NZ Family Court is not fit for purpose, and it's not what the consumers and citizen want, or what is good for a kind, safe, caring society, and adversarial court system for families to fight to the death, just making lawyers and other professionals money. We deem it ironic and hypocritical when these judges and social workers, who outrageously lie in court, are in our homes making rulings that irreparable damage our children, our families, and rubber stamping the lawless activities of CYF/OT without any evidence or proof supported by inept lawyer for child and a lying social worker for OT. Yet this bill wants to give more power to unqualified incompetents who are causing the damage is senseless. There is nothing in place to assure that the children are informed of their rights by their lawyer for children, who's supposed to represent their clients, the children often putting ambiguous and untrue statements before the court. It is time to put in place transparency by having all meetings with children recorded as proof with the lawyer for children, with Orangatamariki social workers, and with the S133 court-appointed psychologists who collectively enjoyed no transparency, no accountability, no consequences for their recommendations, which in many cases negatively affected the children's safety, children's rights, and their entire childhood. There is no guarantee, nor accountability to even following the rule of law. The New Zealand justice system is broken, Minister of Justice tells United Nations. Lawyer for children has no expertise in child protection, no education around a child with disabilities. This means a child with higher needs are totally overlooked and completely misrepresented through the court system, and believes he/she is neo-judge. Papers presented to the NZ Law Society conference. At the end of the day, children's voice will never be heard and taken into account until the lawlessness and perjury, the any evidence rule, is going to be enforced and be punished by law as in the criminal court. Even if it was put before the court by parents or professionals who enjoying immunity and have no consequences of their actions, those players of the court file in bad faith, under no evidence, biased, based on a distorted personal point of views are addressed. Professionals can't write themselves out of the law. and we are all equal before the law. The damage to our next generation, the children, will be imminent in the future. Just another mental health statistics, another substance abuse and drug user, just another violent abuser. Who witnessed one parent hurting the other, but before the family court of New Zealand was minimized, swept under the carpet, or in a high court judgment marked public interest, where the victim of domestic abuse was threatened with loss of custody and imprisonment for trying to protect the children, and in other cases, an abusive parent with drug and alcohol abuse gained custody and the protective parent lost even visitation despite being a caregiver. For Orange Tamariki and has no medical issues or criminal convictions, to the point where a protective parent was fighting against several government agencies to save the children, who's been used and abused in the police operation in John's case. These dangerous practices are irreparable, harming children without any consequences for those players, contractors paid through the family court, and as soon as the final parenting order is made, they do not care what happened to the broken-hearted children, parents. No data, no statistics, no oversight, no accountability, no consequences for any of the judiciary, lawyer for child, Orange Tamariki social workers, S133 report writers and contracted psychological services manipulating, coercing, and forcibly but secretly using the reunification process, which failed, and internationally deemed dangerous practice, which costing thousands and thousands of dollars to further silence the children. Taking a child away from a nurturing parent is extremely detrimental and traumatic. A child additionally placed with a toxic and abusive individual is inconceivably more traumatic. It damages them permanently and changes who they could have been. The previous lost years can never be recovered and is deeply traumatic for both the child and the severed nurturing parent. It's a demise and suffering that extends well beyond what is apparent on the surface or is visible. No words, no picture, no film or documentary can convey the horror, suffering, trauma and grief the child is subjected to. It wrecks beyond comprehension. Family justice system a mess. Justice Minister Andrew Little news of Justice Minister Andrew Little concerned about access to justice in family court. Stuff.co.nz. Key changes required. A royal commission of inquiry into the NZ family court and the associates. Increase mediation services. Remove not increase where possible lawyers and lawyer for child because they are extenuating conflict for monetary gain, not to resolve the issues. Here motivation is to make money, not resolve disputes, and many are milking the legal aid system. Remove without notice applications, as this is a breach of a basic right to natural justice, to face your accuser and be heard. Instill the Evidence Act 2006, remove the hearsay any evidence rule. Charge people for perjury. Aim to resolve disputes in the time frame of the child, 44 days. If lawyers involved, then give them 12 months for resolution and a fixed fee. L4C receives a fixed fee only. No contact order with parents only in extreme cases. Court should facilitate contact in all cases unless violence, drugs, mental health, and criminality is evidenced. Parents who won't cooperate to share children are punished. Breach of parenting order with a 3 strikes and you are out system. Criminal issues to be resolved by courts. Implement an independent review office for CYF/OT. If children are taken, then wrap service around a parent to removal causes mental health issues. CYF/OT to have harsher penalties for criminal behavior including imprisonment. Immediately clear the backlog of court cases. I can think of 3 or 4 real good barristers who could do temporary roles in the family court to manage roles if Judge Doug had the way with all judges to administer the law, be transparent, to abide by the rule of law, and human rights. Government to strengthen government complainant agencies across the board and make them much more citizens-friendly and truly accessible. We have serious concerns at the NZ Police Child Protection Unit and collusion with OT. And how they cooperate, and an independent inquiry is required. Conclusion. Mediated shared care is the only future unless there is family violence, sexual abuse, mental health, drugs, and alcohol. Welfare and safety of the children is the first consideration and paramount, and that goes for all players including the state. New Zealand is not a safe place for children or families in the NZ Family Court with their associates, and until an independent royal commission is conducted, New Zealand has no confidence in any government that continues to support this abuse against citizens. United has have grown much larger as group of intergenerational survivors. More reports and investigation by the state support our allegations, with more to come. What we are saying is credible in the eyes of the people, but it's looking clear we will have to increase our campaign because the ministers and the bureaucrats continue to play politics and ignore our demands. The future generation will judge you harshly, and how you will fix the abuses that has been done to children and parents in the meantime I have no idea, but if you don't make positive change, expect lawful rebellion. https://www.rnz.co.nz/news/national/3921866/family-court-for-70-changes costing up to 60 m a year. The panel was also struck by the lack of trust between different professionals in the family justice sector, which Ms. Noonan said was operating in silos. Ms. Noonan said there was such widespread acknowledgement that the family justice sector was in trouble and seriousness of the consequences for children and young people that the government could not afford to do nothing.